Hey, it's Jeff Timberell. I'm director of the Southwest Florida REIA. I'm joined with Mike Lyons, the other director of Southwest Florida REIA. Say hi, Mike.
Hello, everyone. Welcome.
And we are joined by our speaker, Brad Butcher, who will be speaking this Wednesday at the Southwest Florida REIA meeting about how to fix common title defects. How you doing, Brad?
Great. Nice to be here, Jeff. And hi, Mike.
Good to see you, Brad.
So tell us about Brad.
Well, as you both know, and I'm sure some of your members know, I've been practicing real estate here in the Fort Myers area since about 2006. I do a lot of condominium HOA law, but we also do a fair amount of closings with general civil litigation. So we handle foreclosures and lien matters issues as well. So pretty well-rounded real estate practice.
Nice.
I bet the condos are fun.
Yeah, condominiums are always a challenge. You always get different personalities on boards.
Yeah, board of directors and associations are they're not fun. That's the only way I describe that. That's the most politest way to say that. They're just not fun to deal with.
Actually, I'm seeing some recently that have really went from, the pendulum swings. It went from absolute Jerry Springer show insanity to grown-ups running it, and everything's just calm and normal.
That's a good analogy.
Yeah.
Yeah, you can definitely get the variation. And the well-run condominiums, they, are great places to live and invest in. But you always have the risks of what happens if a different board comes into power.
Yeah.
A new regime comes in. It's like, all right, are they crazy or are they good? What are their motivations for being on a board? Oh, sorry.
Well, there needs to be like a genetic test for friction. This says there's the friction gene. They need to identify it, and you basically give them a blood test. I'm sorry, you can't be on the board. You're gonna.
I'm sorry, you don't pass. Oh, cool. Well, Brad, tell us in the presentation. Of course, we're going to promote your speaking here in 2 days, and give us a little background on what you plan to cover.
Yeah, what I envision is talking about some of the common title problems and what to do about them. And typically investors are going to be familiar with the types of normal run-of-the-mill title issues that pop up on a commitment. Hey, we've got to have satisfaction of an existing mortgage, or we need a homestead affidavit. And those typically are not the type of title issues that really pose any cause for concern. Most title companies handle those, quickly and efficiently. The types of issues, though, that I'd like to cover are the types of issues that don't pop up very frequently, and that when they do can be costly to an investor or lead to a complete change in the economic basis for the investment to begin with. And I think a lot of that boils down to knowing what to look for on the front end, so that if there are some of these hidden title issues, the investor knows on the front end what they are, and then to talk about kind of the options for relieving them, so that, I think probably at the end of the day, it's best for investors to know what they're getting into on the front end, so that they can then build those issues into their deal parameters and manage the risks on the front end.
Hey, Brad, are you seeing any, because when the foreclosure crisis, and then I'd even call it the foreclosure boom, happened, you seeing any issues from that time frame with bad foreclosures, people not being notified, improper deeds, or not?
Not really on a regular basis. I've run into a few, and the ones that I've run into have been more along the lines of there have been a couple that were part of the Robosigning scam, and the bank foreclosure was dismissed because a judge found that the assignments weren't proper, and nobody did anything, and so those open mortgages are still sitting out there. And the challenges with those type of arrangements is then finding a lender and getting, some sort of payoff, or being able to get a release of those old mortgages that are still of record, although, a judge at some point found that they weren't valid any longer. And, those kind of, the couple that I've run into, they haven't been that difficult to remove, in the sense that most of the time, once you alert the lender that, hey, this mortgage is out there and based on this old case, it should be released. In the couple that I've run across, the lenders have simply just issued a satisfaction, cleared it off title, and life went on.
Makes sense.
We have a probate deal I'm involved with personally. We're actually finally about to sell it.
Okay.
In a couple days. On that one, it was interesting because they had a lady who had refied it 3 times, like 2001, 2004, and 2006. And she did it every time with the same title company, who was just writing over. And then somehow they didn't satisfy the middle mortgage in that chain. And it was really problematic for us it took 90 days before we could close.
Yeah. And that is a common scenario where you see where a lender never filed a satisfaction, and they are a bit of a challenge. And it really boils down to just getting to somebody at the lender to go pull the file and verify that those amounts had been paid off, and then to issue a satisfaction. One of the nice things, there is a company called Require that will basically take all that busy work off your hands for, obviously they charge a fee, but they're very good at it because they've got the connections with the lenders, and are able to kind of expedite some of those and get satisfactions. Probates is another area where I commonly see title issues come up. In fact, I had one cross my desk the last week or so, because it was a vacant parcel in Lehigh owned by a family out of state. The original owners have both passed on, and there is a probate order out of a court in some state in the western U.S. Authorizing the heirs to sell the property. But no ancillary probate was done here in Florida. So then the issue is, well, how do you close that transaction? Because that probate order from the court out of state doesn't authorize anybody to sign the deed here and to complete the transaction. So what you would have to do is go back and do an ancillary estate. And so an investor in this scenario would want to know that, so that they could either negotiate that, fee on the upfront, and also to know that to do that estate work is going to take some time. And so you want to make sure that you've got that built into your budget and your plan.
Wow. Would it be tough to even guesstimate how much something like that would cost to fix? Is that pretty tough to say?
Well, if it can be done by a summary administration or an ancillary probate, there's a lot of probate attorneys that will do those on a flat fee basis. And usually those will run somewhere around $1,500, give or take, plus cost. And so, in this particular instance, I think if you're the buyer, you obviously want to make sure that the sellers are going to cover that cost. And there are some ways that you could close with the money in escrow for the funding of the probate, and there's some ways that the heirs could assign their rights so that they're protected while that is proceeding.
Sure.
But you're probably looking at a couple month delay to get the probate accomplished and the expense of it. So it comes down to who's going to pay for it, and how do you manage that in your time frame.
Gotcha. Okay.
What's the going timeline for a quiet title suit?
I usually tell clients that are doing quiet titles between 3 to 4 months if there is no opposition on the other side and there's no challenges in getting everybody served. The challenges typically with quiet titles, at least from my perspective, boil down to, do you have can you quickly get service on the other parties? Because oftentimes what you find is, in particular with tax deed properties, the reason they went into default on the tax deed is usually because there's an owner that has passed, and then you get into the issue of having the time and expense of appointing guardians ad litem and trying to track down heirs, and all of that adds time and expense to a quiet title.
Actually, you probably don't recall, Brad, but a few years ago I was managing an association that you did at least 2, if not 3, quiet titles for us. It was smooth process, and it took about 3 months, maybe 4, to get it all done. And I've experienced that before. It was a pretty easy process. Well, honestly, I don't think we had anyone oppose anything, but it worked out real well.
Yeah. Well, and that's typically the case with the quiet titles, and that's one of the common areas that we'll talk about on Wednesday, because, especially right now, I've seen quite a few vacant lots that were acquired through a tax deed sale and then bundled and sold off to IRAs. And now some of those IRAs are getting to the point where they want to sell those properties, but no quiet title has ever been done. And so again, from an investor's perspective, knowing how to tell if that has occurred, and then being able to either make the decision to negotiate a discounted price to account for the quiet title and knowing the time horizon, or basically knowing that, hey, deal isn't for me, because to maximize value, I really need the quiet title to be done. And this, I've got better opportunities and I don't want to spend the time or the money on this particular parcel. I'll go look elsewhere.
Sure. And I think, if I'm not mistaken, is it safe to say 2,500 to 4,500, again, depending on difficulty and time frame? Is that rough cost, you'd say, or no?
Yeah, on a quiet title, I would say that's a fair estimate.
I know it depends. But.
Yeah, and where they really get expenses is if you have to file a guardian ad litem, because that's usually going to run you somewhere between $750 to $1,000 for fees to pay an outside guardian to file the paperwork with the court to protect unknown heirs. So that's where kind of the quiet titles can really get expensive, if you've got to do a series of estates within a quiet title action.
Makes sense. Okay.
I'm at the point I think I should have to have a guardian ad litem when I go to Bass Pro. Well, I look forward to it, Brad. This is an interesting topic because it's a way to actually increase your deal flow, to get more deals. We were talking about, I'm not going to name them on here, but we were talking about an investor before this who one of his specialties was he would buy stuff at the steps knowing that he had a title issue because nobody else would buy it, and then just take the time to work through the title issue.
Right. And I've seen some more recent investors that still, do that. And, I've seen some very interesting niches, and there are some investors out there that, because they know what they can and they can't deal with from a title perspective, it's certainly a way to get into properties that maybe other investors won't look at because of the title issues, or are unfamiliar with, so they don't know how to price the risk accurately.
Sure. No, that makes sense. And a lot of people shy away from properties with title issues with that concern of not knowing what they're getting themselves into. So that's great. Makes sense.
That's why everybody should have one kid become an attorney.
That's
Absolutely. Right. Especially if you're going to do real estate.
Yeah.
That's right.
Cool. I look forward to it. It's this coming Wednesday, and thanks for your time, Brad.
Yeah,
Thank you, Brad.
Thanks a lot. Looking forward to it.
See you then.